Hey all, here today to talk about an area of family law that's near and dear to my heart, and that's grandparents' rights. In Florida, the history of grandparents' rights has been kind of a bumpy one. By and large, grandparents under Florida statutes have been widely disregarded as far as what rights they have to have visitation or time sharing with their grandchildren. So luckily, in recent years, the legislature has stepped in and created a couple of different avenues for grandparents to assert their rights or to have some rights as it relates to the grandchildren. You know, in Florida, it's a retirement state. We have a lot of grandparents living here, living in the state with their grandchildren. And so we often get calls, do we have any rights? What do we do? I'm going to talk with you today about three different kind of ways that you might be able to look at getting some rights to see your grandchildren. So the first and what I would characterize as the primary way would be under Chapter 752. And Chapter 752:11 sets out kind of a criteria under which a grandparent or grandparents can assert rights to the child. And usually in those situations, it's where both parents are absent, both parents are dead, both parents are in a persistent vegetative state. That's the primary way, or missing. But to establish missing, there's kind of an exhaustive search that needs to be done to make sure that the parents are in fact missing. And that's kind of rare. One of the more common ways that we see is where one of the parents meet that criteria. Oftentimes what happens is maybe mom passed away and dad's in prison. So that's a circumstance under which the grandparents can step in and assert some of their rights. There's other situations where that might come up, but one of the calls we most often get is one parent has passed, the other parent is either in a institution dealing with mental health, missing, in prison, that sort of thing. Or that the living parent poses a substantial threat to the child, and therefore it's in the best interest of the child to be with grandma or grandpa instead of that parent. So where petitions are filed under that statute, the court will have a preliminary hearing to determine whether or not the grandparents have established in their pleading a prima facie case. So prima facie is one of these words that we use as attorneys that we all understand what we're talking about, but the general public may or may not. Basically what that means is, does the pleading on its face assert sufficient criteria for the court to continue hearing the matter? If they find that there's a prima facie case at that point, then there's a whole list of criteria that the court needs to go through, both as it relates to the best interest of the children, and then also as it relates to whether or not the living parent, if one of the parents are still living, presents a harm to that child sufficient in nature for which the court to place the child with the grandparents or allow the grandparents to have a right. So there's a whole list of factors under the best interest standard for the children. There's a whole list of factors under the potential harm from the living parent with the child. Not going to go in those here today, but happy to talk with you about those if you want to reach out and have that discussion. Two other ways that, three other ways actually that you can establish grandparents' rights. It's not generally available under Chapter 61 in divorce actions. However, if the parties, meaning mom and dad, contract in their marital settlement agreement and parenting plan for grandparents to have rights to time sharing with the children, then that's perfectly fine. If the parents contract for it, the court will ratify it, good to go. Another way that the grandparents can get rights are in dependency actions. So I haven't really talked to you guys about dependency actions yet. Dependency actions is where the state finds the child is dependent on the state because the parents are either abusive, negligent, or whatever. So that's one way that can come up. And then lastly is a termination of parental rights and adoption by the grandparents. So that's available under Chapter 63. So these are just some ways that grandparents can assert their rights in Florida. If you have any other questions, please give us a call. Thanks.